Hello everybody, welcome to our group video assignment. My name is Kang Shen, and today me and my group members, Justin, Clarice, Nara and Kelly, are going to critically discuss on the topic of the jury system in the English legal system. So without further ado, let us jump straight into the introduction of the jury system. I believe many of you had heard of the term jury system at some point in your life, but do you really know what is the jury system? Well, here's a brief history about the jury system in the English legal system. So, the jury system was first introduced to Britain after the Norman conquest, and in the early times, the jurors acted as witnesses to provide information about domestic issues. Subsequently, under King Henry II, the jury began to perform important judicial functions, shifting their roles of reporting news that they have knowledge on to deliberating on evidence produced by the parties involved in a dispute. In present times, the jury is seen as a fundamental part of the English legal system, even though only a minority of cases are tried by jury. So, where can juries be used? Juries can be used in the following courts. Number 1, the Crown Court for criminal trials on indictment. Second, the High Court in the Queen's Bench Division for certain types of cases. Third, in the County Court for similar cases in the Queen's Bench Division. And lastly, in the Coroner's Court. So, you may ask, what is the role of the jury? So, firstly, juries decide on the facts and give a verdict of guilty or not guilty in criminal cases. They also decide the liability and the amount of damages in civil cases. And lastly, they also inquire into certain deaths in the Coroner's Court. So that will be the brief introduction about the jury system. And with that, an important question needs to be answered, which is, should the jury system be continued? Our group's answer to that is no. The jury system should not be continued because we have found more disadvantages compared to the advantages of the jury system. And now, we will be discussing about the points for and against the continued use of the jury system. So for starters, I will be talking about the first disadvantage of the jury system, and that is, juries lack competence. According to Lord Denning, the selection of jurors is too wide, thus resulting in the selection of incompetent jurors. He claimed that changes in 1972 have led to the selection of jurors who are not sufficiently intelligent or educated to perform their task properly. One example can be seen in the case of R and Young, where a jury hearing a murder trial had set up an Ouija board to make contact with the deceased spirit. There have also been concerns about the average jury's understanding for complex fraud cases. The Roskill Committee concluded that trial by random jury does not achieve justice in a satisfactory way for such case, where most jurors are said to be out of their depth. However, we can evaluate this point by stating the fact that the Roskill Committee failed to find accurate evidence of a higher proportion of acquittals in complex fraud cases than in any other kind of case. Many of their conclusions were based on research by Baldwin and McConville, yet none of the questionable acquittals reported there was in a complex fraud case. In 2002, a research by Smith and Bailey on the decision-making abilities of the juries suggests that they are capable of reaching reasoned and fair verdicts even in complex cases. Evidence of the police to the Ranchiment Commission stated that the conviction rates for serious fraud, when compared with the overall conviction rate of the cases that are considered by a jury, show that in serious fraud trials, the jury are actually convicting a slightly higher percentage. Terry Holmes concluded a simulation study of jurors' comprehension of some of the evidence in the Maxwell fraud trial. He estimated that 4 out of 5 of the participants could be regarded as competent to serve on a major fraud trial, and concluded that the abolition of the jury system for complex fraud trials are not justified on the grounds of cognitive unfitness.
Hello everyone, I'm Justin, and I will talk about the disadvantages of the jury system. Here we go. It is direct race discrimination to treat someone else less favorably than someone else would be treated in the same circumstances because of race. However, the UK jury system has been repeatedly criticized for its lack of representation of ethnic minorities, which is also a breach of the Article 6 of the European Convention of Human Rights. For example, black defendants have no right to have black people sitting on the jury. The dominant question is whether racial factors in jury panels really cause any impact on the conviction. Referring to a study in America, Summers and Ellsworth found that both white and African American jurors were less likely to vote on convict African American defendants after the race-relevant voir dire. They further proved the importance of racial factors in jury trials by demonstrating juries formed out of all-white jury pools convict African American defendants more often than white defendants. This phenomenon is eliminated when at least one African American is in the jury pool. This suggested the importance of involvement of ethnic minorities in the jury pools when convicting the ethnic minorities. So, in R. and Bansal, 1985, the case involved assault on a policeman at an anti-national front demonstration. The court ordered that the jury should be drawn from an area with a large Asian population. This approach, nevertheless, was rejected as wrong in R. and Ford, 1989, and the Court of Appeal held to not consider races during selection of jurors. And the jurors cannot be discharged simply because to achieve racial representative jury. This in fact will cause a biased conviction as proven in the Americas research that I mentioned above. Moreover, Commission for Racial Equality also stand out and argue that consideration needs to be given to the racial balance in particular case, and they suggested that for those cases which the defendant reasonably believed that fair trial will not be given because of all-white juries, then the judge should order 3 same ethnic jurors to sit in the jury panel. This shows that the issue is serious enough to raise awareness from these authorities. The proposal also gained the endorsement from the Ranchiman Commission 1993 and the Review of Criminal Court 2001, but it has never been implemented, which again highlights the disadvantage of the jury system. Other than that, cost and time also create a problem. We know that the jury trials will happen at Crown Court level, but do you know, it actually costs the taxpayers more than £7,000 per day. It is extremely expensive when we compare to the trial by magistrate, which only costs around £1,000 per day. Furthermore, when the deliberation begins, 12 selected jurors have to set aside their works and children duties, which also create a huge burden to their employers. Since they cannot be separated, they must also be provided with overnight hotel accommodations and meals until a verdict is rendered. Again, huge costs come in here, especially when we know the jury process will be very time consuming. For example, in McLaren against Revenue and Customs, the juror had to listen to 320 days of evidence, and the trial took almost 2 years to complete. It involved too much time and money to come up with a guilty verdict on the defendant. The estimated cost for the trial exceeded £7 million.
Hi, I'm Ziqi. Now I'll proceed with the absence of reasons in a jury trial. At a bench trial, judges will decide the case with a precise and unequivocal judgment. One will get to know the reasoning of the decision through the judgment, as it contains finding of fact and a summary of the relevant law applied. However, at a jury trial, the jury system does not require juries to provide reason for the verdict which they have reached. In other words, they will just state whether they find the defendant guilty or not guilty. This affects the way in which an accused can appeal against his conviction. When judges sit alone, the decision is easier to be reviewed by the appellate court, as the reasons of the court decision are clearly stated in public and published. On the other hand, if an accused wants to appeal against his conviction at a jury trial, the appellate court will not have a statement of the jury's reasoning. The court will have a report by the trial judge on the grounds of appeal, 18 transcript of both the evidence and the judge's direction to the jury, and any documentary or other evidence which are relevant to the appeal. The appellate court, in deciding whether there has been a miscarriage of justice, will therefore focus on 2 things. First, the court will consider the adequacy and fairness of the judge's direction to the jury. and a misdirection by the judge will invalidate the conviction if it has led to a miscarriage of justice. Secondly, the appellate court asks itself whether there was evidence led in the trial which entitled the jury to come to their verdict. According to Article 6 of the European Convention on Human Rights, it guarantees a defendant a fair trial, which includes a requirement for courts to give reasons for their judgment. In Taxcourt and Belgium 2010, the ECHR held that although there is no convention requirement that lay jurors out to give reasons for their decisions, it is necessary for the accused and the public to be able to understand the jury's verdict if the trial is to be considered as fair and just. Therefore, there must be adequate safeguards in place. For instance, the judges have the responsibility to give direction to the jury on the law and evidence, as well as the right to appeal, in order to make sure that the trial is fair, even when the jury does not provide reasons for the verdict. In fact, the juries have considered various factors when they decide the case. A misdirection by the judge may lead to a miscarriage of justice, but it is possible to have other reasons. Nevertheless, the accused will not be informed of the actual reasons of the verdict, as the jury system does not require a jury to do so. An accused will not face such a situation at a bench trial where the judgment is clearly explained by the judges. Besides, technological changes are beginning to cause problems which make us ask how well the jury system can work in the 21st century. We can only wonder how often a relatively low-level case is influenced by a juror or two quietly finding out the fact that the defendant has a criminal record and simply making his or her decision based on that fact. The traditional bar on jurors actively looking for information about a trial or making their own investigation comes under increasing strain now that the internet make it possible to look up at least some amount of any person's history, or to find out fact-specific information about a case that might have been much harder to find out pre-internet. A particular concern is high-profile cases where wild speculation about well-known cases can be found online. It is obvious that jurors should not be paying attention to anything other than what is said in court. A comment on this issue is found in Alex Samuels' article entitled "The Jury is Being Killed by the Internet." According to Alex Samuels, research suggests that a sizable number of jurors do search the internet and even more come across prejudicial material just by accident. This may lead to an unjust verdict, and the judge may order a retrial, which could bring a great inconvenience and cost to the criminal justice system. Likewise, serious crimes such as violence, murder, rape, or child abuse are tried before a jury in the Crown Court. The juries may have to listen to deeply distressing evidence, and in some cases they may have to inspect photographs of severe injuries. There's a news article by Rob Hastings entitled "Jurors Face Increasing Risk of Trauma from Sadistic Evidence in Criminal Court Trials" claim that rising numbers of jurors being traumatized by sadistic evidence in criminal court trial. For instance, graphic photos and video of sexual abuse. Moreover, according to the news article, a jury was reportedly discharged after becoming distressed by the video evidence during the trial of Sion Broughton. Here, the accused had recorded the death of his girlfriend at a music festival after she overdosed on drugs he had supplied. The situation is worsened by the fact that jurors are told not to discuss the case with anyone else. When jurors are distressed, the verdict could be affected. Next, I'll pass on to Kelly.
Hi, I'm Kelly, and I'll move on to the next disadvantage, which is bias in the jury system. Jury gives no reason for the verdict and couldn't discuss any views expressed in the jury room. It leaves the process open to prejudice and bias in coming to the decision. In a recent survey undertaken by University College London, 23% of the jury members were doubtful as to whether they could use the internet to research cases they sat on, and 5% of jury members surveyed admitted to discussing the case they were sitting on social media. And clearly such research may prejudice the discussion of the jury members into making a biased decision unrelated to the evidence of the case. Moreover, jurors may be biased for or against certain groups, like they may favor attractive members of the opposite sex, or be prejudiced against the police in cases of malicious prosecution or false imprisonment. A study published in the British Psychological Society's Legal and Criminological Psychology journal found that pre-trial bias and jurors' understanding of the concept of beyond reasonable doubt have a significant impact on the verdict they are likely to deliver in court. For instance, in the case of R against Young 1995, 4 of the jurors are said to have used Ouija board to contact one of the defendants' alleged victims to find out whether the defendant had killed them. Obviously, this wasn't based on evidence in the case and was only found out as it happened in the hotel room where the jury was staying rather than the jury room in the court. As the content of Court Act 1981 makes it a criminal offense to reveal how a decision on guilt is made by a jury, such secrecy could mean bias. In short, a juror is unworthy of his trust if he has prejudices against any gender, race, class, or religion, or if he entertains a conviction at the beginning that the testimony of the defendant is not to be believed under any circumstances. Lastly, I will talk about media pressure in the jury system. Coverage of high-profile cases may influence a jury decision because they are likely to have been reported in the media for a considerable amount of time before the case even comes to court. This makes it hard for the jury to only use evidence presented in the case. For example, in the case of R against Inner West Coroner ex parte Della Leo, 1994, the first killing happened in 1967, with West only being charged in 1994. Throughout this period, local and national newspapers had reports on missing persons related to this case, and clearly the jury risked being influenced by this press coverage. West tried to argue that this in itself denied her a right to fair trial in front of a jury, but the Court of Appeal held that correct directions by the judge to the jury would ensure fairness prevail. However, with high-profile cases of jury members allegedly doing their own research, clearly media pressure is still a potential disadvantage of using jury members who do not have the professional training to resist such influences. Some people are even affected by their exposure to previous cases in which studies have found out that learning about similar cases can sway the way a person decides about future issues. Next, I will pass on to Nara for the advantages of the jury system.
There are ample safeguards in place to ensure the jury system is effective, fair and relevant. Sections 71 and 72 of the Criminal Justice and Courts Act 2015 criminalizes jury research and research sharing amongst fellow jurors in matters pertaining to a case, as was seen in Attorney General and ELS. Jurors are allowed to deliberate on evidence that is admissible in court and under no circumstances are allowed to undermine the sanctity of evidence by supplementing it with information gathered externally. Under Sections 44 and 46 of the Criminal Justice Act 2003, the prosecution can apply to the judge for a trial to be conducted without a jury when there is a danger of jury tampering, and the judge is empowered to discharge the jury in such circumstances. Judges have the discretion to direct jurors to acquit the accused, and this is the main preclusion against the jury finding defendants guilty in spite of the insufficiency of evidence, as what was shown in Director of Public Prosecutions and Stonehouse. However, what a judge cannot do is to direct the jury to a guilty verdict. In the case of the Crown versus Wang, the House of Lords held that there are no circumstances in which a judge is entitled to direct a jury to return a verdict of guilty and quash this conviction. Thus, in the journey of eking out a verdict from the jury, a judge is expected to act like a legal translator and not an orchestra conductor in influencing the outcome in his or her favor. Dwight Foster, in his article Advantages of the Jury System, observed, It is no unimportant consideration that trial by jury affords a double chance to prevent injustice, since both the court and jury must go wrong before it can be consummated. The certainty of the jury system's verdicts can be seen to return equity into the hands of society. Equity focuses on what is morally right from wrong within the eyes of the law, whereas the law rigidly states what is legally right from wrong. Once the jury reaches its verdict, that finding of fact is cast in stone and cannot be overturned on appeal. This peculiarity is the equalizer to the theoretically unlimited resources of the Crown. The decision reached can be challenged at the Court of Appeal if there was an error in law or there is reason to doubt the credibility of its decision makers. The institutional safeguards established to protect the independence and impartiality of the jury system, such as the selection of individual jurors by ballot in open court and the right of jurors to report the misconduct of other jurors to the judge, are in place to dispel the appearance of bias to the fair-minded and informed observer. As learned and wise lawmakers and judges may be, a whiff of aristocracy and conservatism undoubtedly exists. Hence, the lay nature of the jury system is perceived to be more sensitive to the ever-changing societal norms. In the Crown vs. Cronley, 3 activists sabotaged a BAE Hawk airplane that was destined for export to Indonesia. They claimed their act, which would have prevented war crimes under the now repealed Genocide Act in East Timor, was defensible under Section 3 of the Criminal Law Act 1967. They were found not guilty, leading to much furore and embarrassment on the part of the British government. However, taking into account the last resort manner that led to the sabotage, the growing societal conscience of modern society skewed their verdict and indirectly endorsed their disapproval towards a controversial government policy and exercising their democratic right to express public opinion. Therefore, by consistently failing to return guilty verdicts for certain types of offense, jurors can show that they think the law is out of touch with the times and the law may eventually be modernized. At a more individual level, a juror may react to the facts of a specific case and in effect say that there is nothing wrong with the law, but its application in this case would be unjust. Human rights organization Liberty Director of Policy Isabella Sankey said that the right to jury trial isn't just a hallowed principle, but a practice that ensures that one class of people don't sit in judgment over another and the public have confidence in an open and representative justice system. Perverse as they may be, jury verdicts are not bound by precedent, and thus the diffuse views of 12 men and women rather than one privileged man are arguably impartial and politically independent. As a senior civil servant, Clive Ponting leaked internal Ministry of Defence documents to a member of Parliament concerning the controversial sinking of the Argentine Navy warship General Belgrano in the Falklands War. It strongly suggested that the Royal Navy knew the ship posed no threat to British forces as it was sailing back to port and torpedoed it anyway, killing 323 people in the process. He was charged under Section 2 of the Official Secrets Act 1911, and Ponting contended that the disclosure of the matter to a Member of Parliament was of public interest. Even after the judge has summed up that the jury should convict him, the jury returned a verdict of not guilty. In essence, what was portrayed as treason by those who were aligned with the state was seen as heroic by the jurors, in that Ponting flagged the misconduct of the government and pushed the decision makers to be politically accountable to Parliament. As Sir Patrick Devlin, writing in 1956, said that the last word should rest with the jury remains an insurance policy that criminal law will conform to the ordinary man's idea of what is fair and just. If it does not, the jury will not be party to its enforcement. The powers to insulate the common man against perceived injustice was seen in Bushell's case, where the judge at the trial coerced the jury to find Quakers William Penn and William Mead guilty of unlawful assembly. Their refusal was punished with them being locked up without food, water, tobacco, or heat. Incensed and smelling a hidden agenda and unconscious bias of the judge, the jury changed their verdict to find the accused not guilty. The judge fined and imprisoned several jurors for contempt of court for ignoring the evidence presented before them, and Edward Bushell, the foreman of the jury, took a stand against the judge's view by petitioning for a writ of habeas corpus. Sir John Vaughan ruled in 1670 that a jury could not be punished for contempt of court simply on account of the verdict it returned wasn't to the judge's liking. In the Crown v. McKenna, Justice Castle declared, "It is a cardinal principle of our criminal law that in considering their verdict concerning the liberty of the subject, a jury shall deliberate in complete freedom, uninfluenced by any promise, unintimidated by any threat. They stand between the Crown and the subject, and they are still one of the main defences of personal liberty." The jury system was and still is a shield in protecting the common man from unjust persecution and risk of being adjudicated by one man's prejudice and chauvinism. Today, the significance of Bushell's case is immortalized with a golden plaque at the Old Bailey. The jury system inculcates civic duty by granting lay members of the community the opportunity to be invested in the dispensation of justice. As William Cornish observed, the system has the intrinsic advantage that in drawing upon a steady stream of ordinary citizens, it is not only educating them in the work of the courts, but also, since they are generally satisfied with their own performance, sending them back to their ordinary lives with a sense of the fairness and propriety of the judicial process in this country. Therefore, by doing their part in deciding questions of fact in proceedings, the common folk are subconsciously persuaded to be responsible and patriotic citizens.
To conclude, the advantages and disadvantages of the jury system suggest that structure works well to ensure fair verdicts, judgments, and penalties get issued from the judicial system. Since the structure was created by humans, there are moments of imperfection where innocent people slip through the cracks. In our will, it has to be said that the system of trial by jury is a disadvantage more than it is an advantage. Section 44 of the Criminal Justice Act 2003 demonstrated a much-needed acknowledgement by Parliament that trial by jury is far from a flawless system. Its lack of implementation is concerning. Since society has sought for impartial justice, a radical reformation could be the solution. Notwithstanding the fact that an abolition of trial by jury is seen to be impossible for the time being, some minor changes in the concept of jury system would take England one step closer to the real meaning of justice. That's all for our presentation. Thank you.